Social Security judge revealed to me 3 key factors in approving a Social Security disability case. I want to explain to you what they are. I'm Jonathan Ginsberg. I'm a Social Security disability attorney. And I had a case in front of a judge who is a very interesting judge. She's much more vocal than many judges in explaining what she's thinking. In other words, during the hearing, she would express to me and to my client what her concerns were, what she liked, what she did not like. This is somewhat unusual because normally judges don't let you know what they're thinking. They kind of keep it somewhat of a mystery. This judge was very, very transparent, and I really appreciate that because it's nice to know what a judge is actually thinking. And I'm not sure, by the way, how the judge is going to rule in this particular case. It was a tough case. My client is a younger individual with some mental health issues. She's a very nice person, my client is, and was very credible in terms of her testimony. We'll see what the judge thinks. But the point is that the judge was very, very transparent in discussing what she was thinking. And so one of the factors she talked about was my client's long work history. She made a lot of discussion and engaged in a lot of discussion about my client's long work history, that she worked for 15 plus years in the same type of job, and then all of a sudden in 2016 she stopped, and the judge said, I'm very impressed by your work history. A lot of people don't work the same type of job for that long. What I want to know is why you stopped, and it's really important to me that you address the factors that made you stop, but the work history is very impressive. So what the judge was really saying to us is that my client's work history gave her a lot of credibility, made the judge feel like she was a believable person. So this is no surprise, I've discussed this before, but a long, consistent work history is really important. It makes a lot of difference to a judge, and when you stop working, one of the things you want to address is why you stopped working, and if you had kind of a gradual deterioration in your ability to function, why that happened, and what that entailed, and what some of the factors were, and what the issues were at work, whether it was attendance or interacting with coworkers, supervisors, and the public. You want to be able to explain it, because when a judge sees someone with a long work history, 15 plus years, and then that person stops, the judge wants to know why. As a corollary to this, my client has been working part-time doing various things. The judge wants to know why you couldn't do that full-time, number one, and number two, what problems are you having part-time? Number three, if that job was available full-time, would you try to do it? Could you try to do it? Is your capacity more than the few part-time hours you're giving it now? So when you have part-time work, you want to talk about that. But work history is a really important factor. It goes to your credibility, your believability, because obviously a judge is going to look at someone who's worked for 15 plus years, made good money, had benefits, insurance. Why would they stop? You don't stop doing that. And if you're working a entry-level $8 an hour job, and there's been a lot of inconsistency, the judge may not feel that that gives you a lot of credibility in that regard. Doesn't mean you're going to lose, just means that your work history is not going to be as much of a factor. But if you've got a good work history, use it to your benefit. Let the judge know that you didn't want to stop working, but you had to stop working, and exactly why. A second thing that the judge just wanted to discuss was, and looked at, was the medical records in my client's case. And she pointed out, and she specifically said, that she was a little bit concerned that the medical record was not extensive enough, and it did not address enough, quite as much in terms of work limitations as she would like. And she even pointed out that there was a consultative evaluation, and she read it off and described very, very mild limitations. There was a functional capacity form we had gotten from a treating doctor that described very significant limitations, but the medical record itself did not go into as much detail about the significance of those symptoms, and it really talked about them in terms of being more mild to moderate. She said, I'm struggling with that because, in fact, she even said to my client, I believe you. I think that what you're telling me is truthful. I think you're an honest person. But if it's not in the medical record, I can't approve a case based on what you say. It has got to be based on what's in the medical record. And right now, the medical record does describe limitations. I'm just not sure they're describing them to the level that you're testifying about, and that's of concern to me. Again, judges never do this, but she did. And so she said, therefore, I want you to, this is sort of point 3 here, I want you to explain to me specifically why you contend that you cannot work full time. I don't need to know about the history here. I've got the medical record. Your attorney gave an opening statement, which I did. I want to know specifically what are the activities you can't do, what are the problems you would have trying to work. In a mental health case, attention, concentration, focus, memory, behaving in an emotionally stable manner. I want you, and she didn't say that, but those are the factors she's looking at. I want you to explain to me why you would not be reliable at a simple entry-level type of job. My client went on to do this. So I would tell you that in general, and the judge didn't come out and say it this way, but she was kind of implying that testimony is not really as important of a factor in your disability case as your medical record. You want to have a very, very solid medical record that addresses specific work limitations. And as the judge says, she believed my client. She thought my client was truthful and honest. But without the medical record supporting that, she wouldn't be hesitant to approve. Now, in this case, we had some really solid evidence from a treating psychiatrist in this case. We had some evidence that was not favorable to us from the consultative doctor, and we had additional medical records that showed there was a problem, but it did not go into great detail about work limitations. And my client, to her credit, said to the judge, you know, I can't afford to go to a psychologist on an ongoing basis. I've had to change doctors a number of times because of money or insurance issues, but I've always tried to seek treatment because I've got this issue. And my client also did a pretty good job in explaining to the judge that yes, I was able to work continuously, but I finally got to the point where I could not go on. She probably should have described it as almost a breakdown, which is what it was. But she said, you know, I've tried as hard as I can. I did try to work, but what you don't see in the record, again, a good thing to do, is the deterioration of my performance. In this case, my client had a job where there was a number of different locations for the job. Let's just leave it at that, because I was transferred from one location to the other, and again and again and again, and finally I was terminated. So my client did a pretty good job in explaining how her tenure at work came to an end and why it came to an end. And this was more than was just in the record, because the record just showed she worked for a certain company for a period of time. What my client was able to do was explain to the judge, yes, I was working for that company, but they kept moving me around and changing my job and changing my job description to kind of fit within what I could do, and they were not sympathetic at all to my situation. In fact, they eventually used it to get rid of me. My client did a good job with that. But the judge, like I said, was really explaining to us what her concerns were. You know, she felt that the work history was really favorable. She thought that the medical record did describe a problem, but she was not convinced it described the level of impairment that my client described. And the third thing was that she said, your testimony, while I believe you, is not enough on its own. Now, I've long been a believer that testimony can more hurt you more than it can really help you. It can, if it's good testimony, it'll be neutral. It's not going to win your case. But if it's bad testimony, if you come across as not being believable, it could hurt you. So that's why when you're testifying in a disability hearing, really the less said the better. You want to just be very concise and clear, but you're not going to convince a judge based on testimony, so you want to stick to facts and you want to stick to specifics about work limitations, and you want to try to build up that you really don't want to be there, that you're credible, that you're really fighting the whole concept of being on disability. That's really the best you can do with testimony. Anything else is probably not going to help you at all. So that was the insight I got from a judge. Again, very, very interesting to me. I took a lot of notes at the hearing, not just about my case, but about what the judge was doing, because I wanted to make sure to use for my future cases and to discuss in this video what judges are thinking. And again, we had a pretty clear idea what this particular judge was thinking as in real time as she was going along. So I hope you did find this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, and subscribe to our YouTube channel and our Facebook page. And on YouTube, hit that bell so that you'll get ongoing notices of new videos as they come online. My name is Jonathan Ginsberg, and I wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.